Oh. Okay, I think we're live. Well, good afternoon, good morning to everyone from wherever you might be in this virtual world. I'm really happy. My name's Andy Toole. I'm the Chief Economist at the Patent and Trademark Office. I'm really happy to be a chair. My role is going to be pretty minimal in this session, but I'm super excited to hear about the different papers that we have. The session is called Demographics and Disclosure, Studies on the U.S. Patenting Process and Innovation. They cover really a super interesting set of perspectives here, some of which are, again, about patent processing, and others are just about some strategic use and some applicant choices. I think it's going to be really excellent. So I think what the organization is, there's going to be 20 minutes for the speakers. There's going to be about 6 minutes for the discussants, and there's only going to be a couple, 3 minutes left over for questions. So it's probably going to be only one question. What I would like to do is just briefly introduce the speakers before they talk, just so you know their names and affiliation. But I'm not going to, of course, do any of the justification. I would be here all day with all of these folks with their great achievements. So that's the way we'll work it. If you want to ask questions, please put it in the chat. I will allow as many questions as we can. And if I can be quiet quickly here, then maybe we'll get started and maximize question time. So that's what we'll do. Our first speaker for this morning, this afternoon, this evening, whatever it might be, is Gauri Subramani. She's from Lehigh University, and she'll be talking, her paper is called Attrition and Gender Innovation Gap, Evidence from Patent Applications. And the discussant for her paper, which is going to be Neil Sakatme from Georgetown University. So let me go ahead and start. Gauri, if you're ready, you can share your screen and let me start my my clock. The one thing I'll say is I might be a little bit rude when I interrupt. So please, I apologize in advance for that. So go right ahead, Gauri.
Great, thanks so much. You can all see my screen?
Yes.
Okay, great. Thanks so much, Andy, for the introduction. I'm really excited to be here today. Thanks to the organizers. Let's get going. So this is joint work with Abhay, Aneja, and Oren, Reshef. So I'll start with an example just so we're all on the same page. And this is a real example from my data. There are two inventors who apply for patents in 2010 on new nerve regeneration technologies. And these applicants both are unaffiliated with firms. Neither of them uses an attorney. Their applications are both assigned to the same technology class and the same examiner. So these applications look quite similar on face. Both of the applications receive initial rejections, so not all of their claims are allowed. Then their paths diverge. One of the inventors doesn't respond to this rejection. Their application is subsequently abandoned. The other inventor submits an amendment in response. There's a little bit more back and forth, and eventually in 2013, they receive a patent. So we have two applications which in 2010 seemed as if they were on very similar trajectories, but 3 years later, one of these individuals has a patent and the other doesn't. So there's one other thing I haven't told you that's different between these two inventors. The application that's abandoned is from a woman named Catherine, while the application that's granted is from a man named Victor. So Catherine and Victor are just two individuals, but their differing trajectories and very different responses to rejection are actually trends that appear quite often in the patent application data. Conditional on application, women are far less likely to receive a patent than men. We see that here. This figure shows the likelihood of converting a patent application to an issued patent. So receiving a patent conditional on application for male and female inventors from 2001 through 2010. So what you can see here is female inventors are far less likely than male inventors to receive a patent, and this gap exists throughout this time period. So you might wonder, why we care about this at all. There are two main reasons that I'll highlight today. The first is that these gender gaps can have broader implications on the direction of policies, representation, and innovation. The second is that there are individual level career and pecuniary benefits to participation in these settings. When we think about directional implications of women's underrepresentation, it's important to remember that a lot of the work that determines economic and social rewards happens in contexts with frequent rejection. So if due to their different responses to rejection, women end up participating at a lower rate than men in these contexts, the pool of ideas and talents in these fields will be limited. So for example, female representation in politics can affect actually the direction of policies. If women are underrepresented in applicant pools, this contributes to gender gaps in more senior roles. And finally, in the context of patenting, teams with women are more likely to focus on innovations that serve women, which suggests that these innovations then are less likely to exist if women participate at a lower rate than men. In addition to thinking about the effects of representation on the landscape of ideas and outcomes, there are also individual level benefits to participation in these settings. Inventors receive pecuniary and career benefits from patenting, so there are direct financial implications if women don't patent at the same rate as men. This extends beyond individual inventors to firms as well. Employees at firms that hold patents benefit directly, even if they are not the inventors on patents. Firms that have patents see improved access to financing and better growth outcomes. So this means that if firms with more female employees or female founders and managers are less likely to have patents, this has implications for all individuals who work at these firms, as well as for the success of these businesses more broadly. Differential participation in innovation can have effects that are unexpected and appear in contexts we don't even think of as related to identity or gender. For example, octaves on a standard keyboard are 7.4 inches wide, and one study found that this keyboard disadvantages 87% of adult female pianists. So pianos are actually constructed in a way that makes it difficult for women to be elite pianists. And this highlights how a feature of the piano, which was actually invented by a man, has inadvertently led to female pianists being disadvantaged. This is more broadly illustrative of the ways in which involving diverse populations in the process of innovation is related to innovative outcomes, as well as performance gaps for underrepresented groups. So given this, we ask a few questions. First, do male and female inventors vary in their responses to rejection? Then we examine the effect of gender variation in responses to rejection on patent and innovation outcomes. Finally, we look at what drives this variation. When we look at the effect of gender differences in response to rejection, we find that female inventors and majority female teams are more likely than male inventors to abandon their applications after receiving a rejection in the application review process. Applicants that use attorneys are more successful, and female applicants benefit more than male applicants from the advice of an attorney. Similarly, having firm support of an application decreases, but doesn't eliminate the gap between male and female inventors. Broadly, women are underrepresented in patent applications. This is unlikely to be news to any of you. Fewer than 15% of patent applications have at least one female inventor. So put differently, this means that more than 85% of applications come from male inventors or all male teams. Conditional on applying, as we saw earlier, women are less likely to receive a patent. So not only are they underrepresented at the outset, but this worsens over time in the patent review process. The patent review process is highly iterative. So just like research, academia, and innovation more broadly, rejection is very frequent in this setting. More than 80% of applications receive initial rejections. But just receiving this rejection doesn't mean that the ideas themselves are of poor quality. It pays to follow up here. 63% of applications that receive an initial rejection are eventually granted a patent. So what we do in this work is we examine the evaluative trajectory of applications. So the unit of analysis here is an application. And we ask, where do applications drop out? The data we use is from the USPTO on patent applications from 2001 through 2012. So one thing to note here is this is applications and not just granted patents. We limit to applications for which all inventors are US-based and for which we can identify the gender of all inventors. We have almost 1 million applications here. And what makes this a really rich context in which to study innovation is the ability to observe each interaction and stage. So you really have a full map of the process that applications go through. I'll talk you through what the evaluative trajectory looks like here. And I'm focusing just on applications with single gender authorship. So applications that come from individuals or from single gender teams. Together, these account for almost 90% of the sample. So this is really broadly representative of the full sample. So first, when you submit an application, there are two outcomes that happen right away. Either you receive an initial rejection or the patent is granted. One thing to note is I'm just showing raw proportions in this figure, so no controls. You'll see that it appears that female applicants are more likely to have their applications immediately granted, but this difference goes away once we add in controls for art units. So if you get a patent right away, that's great, you're done, but far more likely is the outcome of receiving an initial rejection. After receiving an initial rejection, applicants can either follow up and respond to the examiner's comments, or if they don't follow up after a certain amount of time, the application is considered abandoned. Then the process continues on from there. There's the potential to receive another rejection and respond again. One thing to note is that even after receiving what's deemed a final rejection, inventors can still respond to examiners' comments. So this is really quite an iterative process. But what we'll be focusing on today is what happens after this initial rejection stage. So submitting a response, an initial amendment. And what we see just looking at these proportions is that male inventors are far more likely to respond after the receipt of an initial rejection than female inventors are. So almost 22% of female inventors abandon their applications after receiving an initial rejection, whereas for male inventors, that number is just 13.5%. This has downstream implications for what ends up existing. So 63.6% of rejected applications with male authorship eventually convert to patents, whereas for applications with female authorship, that number is just 49.2%. Ideally, we could directly evaluate the effects of rejection on continuation in the patent process for male and female inventors. So one way to do this would be through an experiment in which rejection was randomly assigned, and then we could measure how male and female applicants respond differently to rejection. But we can't run that experiment, and in the administrative data, quality is a confound that can affect both the likelihood of receiving a rejection and the decision to continue on in the process. So in order to deal with this, we use an IV approach that takes advantage of the fact that patent examiners are quasi-randomly assigned to applications. What this strategy uses is the fact that patent examiners vary in how stringent or harsh they are. Some patent examiners are far more likely to give rejections than others. So in order to use this as an instrument for rejection, we want to make sure of two things. The first is that examiner harshness actually captures some of the variation in initial rejection so that it's actually relevant. We're able to test for this by looking at the first stage, and we find that an examiner's prior rate of rejection has a very significant effect on the likelihood of receiving an initial rejection. This is robust to the inclusion of covariates that measure characteristics of the application and applicants, as well as including subclass fixed effects, as Tim would recommend we do. So we're pretty confident that this is actually a relevant instrument. Then the next thing we want to make sure of is that examiner harshness affects the outcome variables only through the rejection so that the exclusion restriction is satisfied. So for examiner harshness to be a good instrument, there shouldn't be a relationship between an application's quality and how harsh the assigned examiner is. What this figure does is relate examiner harshness to two variables. The first is the actual initial rejection rate, shown in red, and the second is the predicted rejection rate, shown in yellow. So by construction, the initial rejection rate is perfectly correlated with examiner harshness. This is how we measure examiner harshness. Predicted rejection is based on observables that proxy for quality. So these are things you can see just on face about the application. Things like the number of inventors on an application, the proportion of female inventors, whether the application is assigned to an employer, who that employer is. So what you see here is there's no relationship between an examiner's harshness and these covariates, so we can confidently say that we're satisfying the exclusion restriction. I'll start by showing you our main results using the instrument for initial rejection. Before I get into our estimates, I just want to talk you through these female definitions. So in order to make sure that our results weren't sensitive to one specific way of defining the presence of women on patent applications, we try a few different things. First, we just look at the proportion of women on an application. This is really more of a directional indicator. Half female is equal to 1 for applications for which authorship is 50% or more female. All female is equal to 1 for applications with all female authorship. And then we just look at solo inventors and compare solo female inventors to solo male inventors. The first row here shows the effect of receiving an initial rejection on continuing in the patent process and submitting that initial amendment. So what we see here is that applications from teams made up of 50% or more women are more than 3 percentage points less likely to submit an amendment when compared to applications from majority male teams. And when we focus on applications from all female teams and solo women, this effect increases. Then when we look at patent receipt, or the likelihood of converting to a patent eventually, the effects are even greater in magnitude. Teams with 50% or more women are significantly less likely, more than 5% less like 5 percentage points less likely to receive a patent than teams with fewer women that also receive rejections. So given that there's such a strong effect of the first rejection, we were interested in if multiple rejections contribute more to this gender gap. Interestingly, that doesn't seem to be the case. Female inventors are not less responsive to rejections that occur after the first rejection. So all of the action is really at this first initial rejection stage. So then we're interested in understanding what's going on here and why this might be happening. So we examine how institutional support, which we operationalize as organizational support, legal representation, and the broader institutional environment can contribute to or mitigate these gender gaps. So starting with organizational support, applications are assigned to organizations. They have an assignee, generally when the inventor is an employee at that organization or firm. Firms usually have internal processes to determine which ideas to pursue. So for example, a patent committee to which employees have to bring their ideas if they want to apply for a patent or they think they have something patentable. Firms pay for attorneys to represent applications most of the time. And 63% of applications in our sample are affiliated with firms. We look at both the net effect of being affiliated with the firm and the effect of organizational experience based on the logged number of previous applications filed by the organization. Then we think about legal representation. Patent attorneys have specialized knowledge. They're required to pass a USPTO registration exam before they represent patent applicants. The patent attorney generally handles all communication with an examiner and solicits input and information from the inventor as needed. More than 95% of applications in our sample use an attorney. We evaluate the overall effect of using an attorney, as well as the effect of using a lawyer who works for firms that are among the top 50 or 100 law firms in the US based on rankings from vault.com. And then finally, we're interested in the effect of the macro environment in which an inventor works and lives on the gender differential in responsiveness in the patent process. So we use ACS data to evaluate the average gender wage gap in an applicant's industry and state. One thing to note here is we can only estimate this for applications that are assigned to an employer because those are the applications for which we can identify industry. This figure shows the differential effect of our measures of institutional support on the likelihood of submitting an initial amendment, so following up on that initial rejection. So if we start by looking at our measures of organizational support, we see that having an employer affiliation increases female inventors' responsiveness to rejection significantly by about 5 percentage points. And this is the differential effect for female inventors over male inventors. This effect increases with firm experience with the patent process. When we look at the effect of an attorney, we see that using an attorney helps women differentially. So it helps women more than it helps male applicants. And then finally, when we look at the effect of the environment that inventors work in, we see that pay equity in states has a significant effect on closing the gender gap. We conduct the same analyses to see the effect of institutional support on the likelihood of converting to a patent. And we find that these effects are very similar and actually more significant. So together, these results suggest that these types of institutional support can substantially mitigate the gender gap in patent application conversion. One thing to note, though, is that while these measures help decrease the gap, we still find significant differences between male and female applicants. So even under kind of these ideal conditions, there still is a net gap between male and female applicants in both responsiveness to rejection and eventual patent grant. So overall, what we find are that female majority and all female teams are significantly less likely to continue in the patent process and be granted a patent if they receive an initial rejection. Interestingly, this gap in responsiveness to rejection widens as the presence of women on inventor teams increases. So the intensive margin of female representation appears to matter here. We see that affiliation with a firm, guidance from a lawyer, and the context in which an inventor works and lives can reduce the gender gap, which suggests that institutional support and resources can play an important role in improving outcomes for women. So there are some implications here that I think are quite interesting. The first is that female innovators' ideas are under-leveraged even within organizations. So even when they're affiliated with the firm, female inventors' applications are less likely to end up converting. This suggests that there's a potential source of comparative advantage for firms because they have this potential for increased net innovation, as well as if women are actually more likely to innovate for female consumers, increased and improved female-focused innovations. In addition, gender differences in patenting outcomes might be one major contributor to differences in entrepreneurial formation and the success of new ventures. And finally, we see that female innovators are less likely to reap the benefits of their innovations. They've already developed these ideas at the stage at which they're applying for a patent. They're less likely to end up being able to actually capitalize on this either in terms of promotion or cross-firm mobility as far as how they can signal their skills based on having a patent, or direct financial benefits if they're able to commercialize whatever they do. One of the features of this work that I think is the most exciting and interesting is its direct policy implications. What we see also is that the patent evaluation process itself can be a lever for increasing female representation in patenting. If after receiving an initial rejection, applications from women were continued at the same rate as applications from men, there would be 13% more majority female patents granted. And this is over 7,000 more granted patents. So this is really a meaningful potential increase. So these results suggest actionable implications. And we'll hear more about this from Nick very soon, but things like the Pro Se Assistance Program that USPTO recently began, in which unaffiliated inventors without an attorney can access resources and information about the process, along with free legal representation, are really potential ways to move the lever in this context. Thanks so much for your attention. Really looking forward to questions and thoughts from Neil. Thank you.
Thank you very much, Gauri. That's perfectly on time. And so let's transition over to Neil and get his comments. You have a total of 6 minutes. If you take less, I won't be unhappy.
Thank you. Let me, I put together a couple of slides. Let me just see if I can get that up. And can you see the slides?
When we can see your others, you have 2 screens. It looks like we see one screen with a lot of icons. It says update available for status 17.
Okay, let me put the other screen then up. Yeah, I gotta clean my screens up. All right, let's see. Now can you see it?
Yes.
All right.
It has 2. It's broken into 2. There you go. Yep.
There you
Looks
go.
good. Looks
Okay.
good.
Well, thank you. I really enjoyed reading this paper. Let me clear my screen so I can actually see your faces too. Great. Great. So thanks again. So I really enjoyed this paper. I've sort of 3 main comments. I want to go through them quickly because we don't have much time. First, I really found the focus on attrition interesting. I'm just want to sort of talk through and see, are you measuring sort of what might be called a discouragement factor here, right? Women applicants get a rejection and they're more likely just to kind of leave the process, or is it something more focused on the fact that they haven't been maybe informed on like the fact that the patent process usually starts with this sort of a rejection, right? And also heterogeneity across different kinds of applicants, so we'll get into that, right? I'm also interested in just seeing whether there's a potential longer term impact impacting the career cycle, so I'll go through that. I think you can also focus more on heterogeneity across patent applications. And then also, I think it'd be interesting to look at conditional on responding to office actions. Are there gender specific differences? So let me dive into each of these 3 points a little bit more. Okay, so supposing what's going on here is a story of discouragement, right? First of all, we might think that there might be an effect on people's career cycle in a way that's longer than what you're actually measuring, right? You're focusing on one particular kind of what happens in this patent application. But there's this literature, right? If you enter a job market during a recession, right, that's going to have longer term impacts on your wages. So similarly, right, are these effects that you're measuring here on gender potentially propagating downward into future patent applications? And I believe you connect based on the log of experience, right? You connect already across patent applicants over time. And so I think there might be a way of actually measuring and seeing whether the effect you're talking about here actually propagates and is actually more impactful. And it would fit into this literature that suggests that if you get bad luck of the draw in terms of the examiner you end up with in the beginning, that could actually cause more issues for you. I think you can do this in a few days, right? For example, I think you could do a triple difference where you interact with the sequence number of the applicants encountered at the PTO and sort of see whether the impact is greatest, right? You think that if you get unlucky with a tough examiner, I shouldn't say bad examiner, a tough examiner earlier on, right? If you end up with a tough examiner earlier on, maybe that's going to affect you more than if it happens in your third prosecution, right? So I think seeing what that effect would be interesting. Obviously, there's going to be sample issues in terms of, when you're talking about female inventors, that's already a smaller pool of the population, but I'm sure there are ways in which you can come up with specifications where this might work. And again, you could obviously use a different outcome variable, the effect of an initial rejection, looking just at the first one on all future patent grants. All right. So second of all, right, I was wondering about heterogeneity here, right? Are these results concentrated in particular subfields? Is it more of a concern in certain industries as compared to others? So I think now that you've identified this effect, which, and others can talk more about other challenges to what you're talking about here, but I tend to think that your IV is pretty solid here. You might want to look into heterogeneity into different areas and see where the differences are largest. And if they accord with, and ideally, if you sort of think about what kind of ex ante theory you might have as to what industries in which you'd expect there to be more differences, you could test that to see, right? I think you could also add more controls directly to the IV specification. So right now, what you tend to do is you have certain controls for art unit year, and you have applicant fixed effects in various tables. But you also have some controls in table 5, right, based on assignee dubbing, log of experience, et cetera, whether there was an attorney present. I didn't see, and maybe I missed this, but I didn't see specifications where you just included those in the IV itself at both stages. But I think that would be sort of I'm just curious to see what the results would be. You kind of took each one separately as a triple difference. I think that would be good. I think there are also other controls that might be useful to add. So for example, for the issued patents, right? One question would be, what's the kind of difference in value across these patents for the issued patents? And you can use the Kogan data to be able to kind of, go into that a little bit more. I also didn't see much of a discussion of the type of rejection that the folks received. So, everyone here kind of knows what this is, but a 102, a 102 novelty rejection is different than a 103 non-obviousness rejection. And it would be interesting to see if male and female applicants are receiving different rejections, and that could be part of the reason why they're getting sort of different responses right here. Another thing which struck me here is, when you are represented, right, the decision and you're an assignee. So when I was prosecuting patents, right, the decision of whether to continue or file a response would not come down to the inventor. It would come down to the attorney and their in-house counsel. And so I'm a little bit somewhat more skeptical of the situation when you have a represented client, that the inventor's gender is really necessarily playing a role directly. Now, it could be playing a role indirectly through biases of the attorneys. So one thing that would be interesting is to look at the attorney gender, and you already have the data on that. That might be something which you can add into there. The in-house counsel is going to be a little bit trickier, but those are the people who actually in the end make a lot of the go, no-go decisions in terms of office action responses. And if they're experienced players, they're going to know that most likely you're going to have to at least have one office action response to begin with. So when they're filing the patent application in the first place, they kind of know, okay, yeah, we probably will need to file this in the first place, that response. And they budget for that cost up front. Another thing to keep in mind, the vault rankings that you use, I think might be misleading. So first of all, use top 100 firms and then top IP firms. That's not the same as a top patent prosecuting firm, right? So the margins on patent prosecution work are much less than patent litigation. And patent litigation is not the same thing as IP litigation. So I know you've used a proxy for top IP firm, but some of those firms might not be prosecuting very many patents. And so what you might instead want to do is go based on the ranking or the list of number of patents prosecuted as a way of identifying the ones that have the most sort of experience. Okay,
Neil,
and then finally,
Neil,
I think one other thing you can do is do a little bit more. Oh, sorry. Analysis of office action responses. So conditional on responding, how do male and female applicants differ in the language they use in office action responses? So one thing is you mentioned the idea of it being an amendment, but it's not always an amendment. Like a lot of times when I was responding to office actions, I would just make an argument, especially if it was a 102 rejection and not an amendment. So men and women might differ in terms of whether they actually argue back at the examiner or whether they propose an amendment. And that's something which you could look at, I think, relatively easily. Which is worth looking at. And obviously you can then go into text analysis too, to actually look at the differences in the office action responses too, but that's going to be a little bit more involved. Sorry, I was a little bit over. Thanks.
All right, thank you, Neil. There is a question. I'm going to let you look at that yourself, Gauri, in the chat. It's kind of a comment, but I think we need to move quickly on. We're on a tight schedule apparently in our schedule here. So the next speaker is going to be Nick Pairolero. He's at the U.S. Patent and Trademark Office. The paper that he's going to be talking about is very related to what we just heard about. It's called Patents and the Inventor Lifecycle, Evidence from a Randomized Control Trial. And the discussant is going to be Cassidy Sugimoto, who is at Georgia Tech, and we're looking forward to that. So Nick, go ahead. 20 minutes, and Cassidy, you have 6 minutes.
All right, great. Thanks a lot, Andy. So yeah, the paper is called Closing the Gender Gap in Patenting, Evidence from an RCT at the USPTO. And my co-authors are Charlie deGrazia. He's in Paris at EMLV. Peter Anthony Pappas. He's a supervisory patent examiner that had a direct hand in the thing that I'm going to talk about here today. Mike Teodorescu, he's at BC, and then of course Andy. We've been hearing a lot from him today. So let's get into it. So a lot of this, I mean, Gauri did a superb job of kind of motivating what I'm going to talk about here, much better than I could do. But I'll just kind of re-summarize this stuff again. So basically, the gender patenting gap is quite large and it's very persistent. In 1976, the gap was, it's the percentage of inventors that are women was like, 5%, something like that. It's risen to 13% in 2020. So it has increased, but it is still, there's a big gap there. And this leads to probably a lot of things. It could reduce the rate of invention and innovation. It also sort of, redirects, where invention is happening. Different people, different groups, they have different ideas, different focuses, and kind of changing who's inventing might sort of change where we are inventing. So again, the gap is not closing quickly, so it suggests there might be a role for policy in some sense, but it's a really, really hard problem. There's a lot of potential reasons for this gap, and it's not well understood. There's a lot of literature that's sort of coming out recently, so we are kind of learning a lot about it, but I just kind of think that it's a hard problem, and it's tough to sort of figure out where we should target policy. So to kind of start here, we'll look at how people are entering the patent system, and to do this, we kind of look at the fees that they're paying. So they're called small and micro entity fees. Really, that is just sort of identifies whether or not they're an independent inventor, right? They're sort of just filing an application without a firm, without a company, or they're filing with a small business. And we kind of look at over time since 2000, and people are more likely to file patent applications as first-time inventors with small businesses or kind of by themselves. And if you look at women inventors, the difference is about kind of 5 percentage points more. So in 2020, about 50% of women inventors are filing with small businesses or independently. And that's again about 5% more than men. And then we'll kind of look at the gaps, right? So who's getting patents? And if you're a woman inventor, right, the difference in whether or not you get a patent or not is between 3 and 5 percentage points. So that's kind of the top line here, woman inventor. Baseline is about 3%. You add some fixed effects, gets a little bit bigger. If you're a US inventor, it's a little bit bigger. And then if you're a new US inventor that's filing with a small business or an independent inventor, the gap is about 5 percentage points. The last two columns we do kind of at application level. This is what Gauri was talking about. There's different ways to kind of measure at the application level. Do you have at least one woman, or are you, the kind of proportion of women? They all kind of produce the same results here. The first 5 are at the inventor level. So resource constraints and patenting outcomes. So again, right, we see this sort of increase in inventors that are filing patent applications when they're first starting out with small businesses or by themselves. Women are more likely to do so. And then the women inventors, they have between a 3 and 5 percentage point gap of whether or not they get patents, right, when they're filing with small businesses or independently. And the idea here, again, this is what Gauri was talking about, is that inventors that don't have that are kind of filing applications here with small businesses, they may not have the institutional support of large companies, right? The sort of all the patent attorneys and all these resources that might be beneficial to allowing them to better kind of prosecute patent applications. And this is Gauri's paper here. I mean, basically, women are more likely to abandon applications after their first rejection. The gap is larger with when they don't have institutional support. So this suggests that policies targeted towards lowering the costs of patenting could be especially beneficial to women and sort of help close that gender patenting gap. So now we're getting into sort of what we're able to do here. So in 2014, the USPTO, they established an art unit. Okay, it was called the Pro Se Pilot. This sort of stemmed from political forces in AIA, but also an executive order from the president. And they established this art unit to better assist patent applicants that did not have legal representation. So these people, they're called pro se applicants. It literally means you try to prosecute the patent application by yourself. You're not using an attorney. So it's, about 15 patent examiners, they were put in this art unit. These were highly experienced examiners. And they were given, a lot of training up front, about 20 hours. That wasn't the extent of it. Throughout the process, they would kind of meet, discuss best practices, these types of things. They were also encouraged to do more interviews with the patent applicants to try to sort of convey, right, the reasons for why their patent application may not be valid at that point in time, but what they could potentially do to, get a patent allowance later on. So it's sort of like, you can think of it as kind of more customer service oriented patent examination, more or less providing better assistance to these applicants that did not have legal representation. And I guess the really important thing for our purposes is that when they first started the pilot, they randomly allocated the pro se applications between a treatment, which was the pro se pilot, and the control, right? They just sort of threw the rest of them out into, the wild world of patent examination, and they were just kind of prosecuted the way they would have been had the sort of pilot not been there, more or less. So yeah, they basically randomly allocated the applications. So we have an RCT here. So our research question is, okay, by lowering the cost of patent prosecution, did the PSP, that's the pro se pilot, differentially improve outcomes for women inventors relative to men? So just to make sure we have a reasonable randomization here, what you can do is check the pre-randomization characteristics of the applications between the treatment, the PSP, and the control. And we have all of these characteristics: the filing year, the team size, do you have a US inventor or not? We have these scope measures. So for those of you that don't spend your lives dealing with patent applications, the scope is, you can think of it as kind of the breadth of the invention. So how broad is the invention that they're allowed to get? How narrow is it? That type of thing. A couple of measures that are kind of well validated. People are using these a lot now in the literature: incoming patent application scope, ICC, ICL. Then we have the measures of female representation, and also the experience of the inventor, how many patent applications you filed in the past. And the bottom line is that there's no statistical differences in these pre-randomization characteristics between the treatment and control. So we think that the randomization was a good one. So to get to the results, Again, we're looking at the differences in whether or not you got a patent or not, whether or not you were in the treatment group or not, and the heterogeneous treatment effects, were you a woman inventor or not. So if you look at the top line, again, we have a series of specifications that change the covariates, they change the sample a little bit. But the bottom line is that if you were in that treatment group, if you got the better examination assistance of the examiners in the PSP, you're between about 5-6 percentage points more likely to get a patent, whether or not you're a man or a woman. Now, if you're a woman, if you look at the third row, we see much larger treatment effects, right? So basically you get the baseline, but then you also get the difference if you're a woman inventor, and that's between 11 percentage points and 12 percentage points between 1 and 3 by just adding additional covariates. If you are a US inventor, the difference is a little bit larger at about 15 or 16 percentage points, but if you're a new US inventor, it's 20 percentage points. So if we look at column 5, the gender patenting gap there for a new US inventor is 14 percentage points, but then if you're a woman and you're in the treatment, it kind of completely reverses this gap. So there's no longer a gap. And minus 14, and then we kind of add 20 percentage points to it. The last two columns, again, we do an application level analysis, kind of changing the way we define female representation, and we get the same results. Now it gets interesting when you start to break it down by the technology area. So we have these kind of broad groups of patent examiners at the United States Patent and Trademark Office. They're called technology centers. TC is technology center. They are very broad aggregates of technologies, and they're kind of meant to kind of group technologies, but because they're so big, you have a lot of differences still there. But what we're finding is that when we look at the impact of the treatment and the heterogeneous treatment effects, in the technologies where women have the worst relative outcomes, you have the biggest gap. That's where you're seeing the reversal, okay, with the treatment. So, for example, if you look at TC21, that's computer architecture, it's software. You see a gap of about 25 percentage points, and then when you have the treatment, you have an increase of about 30 percentage points, right? So it kind of, again, we see it reverse the gap, and you have a little bit on top there. TC26 is communications, networking, that type of thing. Again, we see a pretty big gap of 20 percentage points, and then a complete reversal of 35 percentage points if you're in the treatment. So if you kind of combine those two areas, those are where you have the biggest gaps. That's where we're seeing the heterogeneous treatment effects. If you look at TC17, that's chemistry. A lot of previous research has shown that women have much higher representation in chemistry and the life sciences. Here we don't even see a gap. Okay, women are just 23 percentage points more likely to get a patent there. There is no gap. We don't see any impact of the treatment there. So I mean, the idea here, what we're seeing from this table is that in this sample, where women have the worst relative outcomes, you do see the biggest impact of the treatment being randomly assigned to the prostate pilot. So overall, we see the PSP. Again, this is the group of examiners that were sort of, assigned to provide better or different sort of customer service to prostate applicants. They're applicants without legal representation. Overall, we see an increase in the grant rate by about 5 or 6 percentage points. We see a much larger increase for women relative to men, between about 11 percentage points and 15 percentage points for new inventors. And if you look at kind of closing the gender patenting gap, it completely closed the gender patenting gap in this sample for new US inventors and in areas of technology where women had the worst relative outcomes. In our sample, that was software, computer architecture, communications in these areas. So we have a variety of, kind of extensions and robustness checks. The first one is what we're digging into right now a little more. I'll tell you what we have done. So we're trying to get at, what exactly is happening in this treatment group, what exactly is happening in the PSP. We have a lot of ideas about what was meant to happen because, Peter Anthony, my co-author, he was, directly involved with this pilot. But what we've done here is, there were highly experienced examiners that were assigned to the treatment. So the first thing we did was control for the experience of the examiners, just to make sure that it wasn't just, more experienced examiners that were behaving like this. And, the results persist after that. So you still see this very large heterogeneous treatment effect. we also put in the propensity of the examiner to allow patent applications. There's a lot of discussion about different examiners that have different allowance rates. We put that in there. We still see this heterogeneous treatment effect, so it's not, that's not driving it. They were encouraged to do interviews with the applicants. We haven't looked at this yet, but I would like to see whether or not there were, more interviews in the treatment relative to the control. That's kind of more face time to convey the legal nuances of prosecuting patent applications. So we are going into this more to kind of try to figure out exactly what's happening in this art unit that's sort of causing these results that we see. Then we also check, well, look, hey, so we have a treatment, we have different type of patent examination that's going on, we have a higher allowance rate. Is it resulting in different patents, right? And here we use our scope measures. The treatment effect, it didn't result, or the treatment didn't result in, patents that had less scope on average. They're, at least on that characteristic, they were the same. So yeah, I mean, basically you have a higher allowance rate, but it didn't result in, different quality patents, at least in terms of patent scope, which is one dimension. Then also, when you run RCTs, right, you can have spillovers, right? Basically, a lot of the stuff that we did was at the inventor level. We also did patent application level, which is not necessarily going to be affected by spillovers, but so we could, at the inventor level stuff, you could have an inventor that's in the treatment. They had an application that was treated, but also have an application that was simultaneously in the control, right? And in that case, it could kind of bias your estimates downwards. So what we did was we kind of took out those few inventors that did happen to have two applications, one that got assigned to the control and one that got assigned to the treatment. And we see the same results, right? So there's not really a big impact of spillovers there. And then finally, we've done a couple of robustness checks, nonlinear binary outcome models. We get the same average treatment effects. And then we've also clustered the standard errors at various levels. When you have kind of treatment correlation within clusters, you want to make sure that you cluster your standard errors. So here we have, by the way that the applications were randomly assigned, I didn't describe it too much, but there was some correlation because of the technology centers in the way that they were randomly assigned. So we cluster at the TC level. We also cluster at the application level because all the inventors within an application, they were either treated or not. So we cluster there and we get the same results. So that's it for that. So then finally, okay, so again, our sort of motivation is that first-time inventors are increasingly likely to file applications with small businesses or independently. These applicants are less likely to have the institutional support, right, available at larger firms that can come in sort of a variety of forms. Women are especially likely to start inventing in this way, about 5 percentage points more likely. And this could potentially lead to worse patenting outcomes, right, if you don't have this institutional support. So the PSP, it kind of directly, intervened, I guess, within this mechanism by providing kind of better customer service, explaining the patent prosecution process, explaining the legal nuances of this procedure, which is quite complicated. And in doing so, it completely kind of reversed the gender patenting gap for new US inventors in the pro se sample, but also in areas of technology where women have the worst relative outcomes. So I will leave it there. Thank you very much, and I look forward to questions and comments. So thank you.
Great, thank you very much, Nick. That's awesome. Very interesting. Good compliment to the first paper. Now we have Cassidy Tsujimoto, who's going to, from Georgia Tech, who's going to discuss. Cassidy, can you share your screen?
As soon as Nick stops sharing, I believe I can.
Okay, yeah.
There it is.
Excellent.
The small little red
Awesome.
button. Thank you so much. Well, I'm delighted to be here and grateful for the opportunity to be a part of this conversation. I'm not sure why it is. Excellent. Everyone can see my slides showing up well?
Yes.
Okay,
yes.
Perfect. I think that this is just a critical question for S&T policy. So I'm delighted to be able to take a closer look at this work and also to hear the conversation on the other works presented today, which I agree with Andy are just a beautiful complement to one another, and I think really lead us towards some future directions here. So One of the things that has already been covered, but I'll briefly go over because I think it's important to set the stage, right? We know that women are underrepresented in patenting. We've seen that applications with women inventors are less likely to be granted. And then when we dig into that, I think Gauri's work is just a wonderful example of what happens in that process then. They are less likely to appeal or to continue after rejection, suggesting that there's something happening in the process of the USPTO which warrants an examination. And then, as has been discussed in both Gauri and Nick's presentation, the scope of women's work is more likely to be narrowed as well. And this has implications for sort of the value, the contributions, and the understanding of women's labor as inventors. So the argument that the paper comes with is it says the causes of the gender gap are complex and not well understood, even though they do acknowledge that recent research has begun to cast light on this issue. And then there is the claim that we must first understand how women are entering the patent system. So I wanted to sort of provide a quick rebuttal, and this may be more rhetorical than anything else, but I think it's important to go in. One is that when they cite the recent research, it's 2005, 6, 7, 12, 13, 15. And I would make an argument that over 2 decades of research in this area suggests perhaps that we don't lack information on the gender gap, but perhaps we lack more information on the USPTO. And I think that this is a really important element, is there have been dozens, hundreds of articles that have looked at women's patenting and women as inventors, looking at different sectors, looking at mentorship, a host of other ethnographic studies, case studies, sociological studies, organizational theories studies. But what we don't really understand as well is what's happening within this system of the USPTO. So I would suggest a rhetorical shift. Instead of saying we need to understand women, what are women doing right or wrong, but we must understand how examiners are receiving women into this system, how the USPTO acts as an agent in this process and in this system. And I'll reference this article from last year from Schuster, who looked at women whose gender was identifiable on the patent applications, that is, names that are highly associated or highly identified as being a feminine name, versus women who had very neutral or androgynous names. And what they found was that women whose names were strongly feminine were significantly less likely to secure a patent relative to women whose gender was not as apparent through their name. And the authors suggest that maybe this is evidence of bias against women in the patent office, either explicit or implicit. So I think it's really important for us to sort of reframe and understand the reaction to women, the receptivity to women as they enter into the system of the USPTO. I think both, though, regardless of whether you frame it as it's currently framed or reframing it like that, they both lead to the same design. And that's what I love about this paper, is the way it has been designed. One is that it is situated firmly within the USPTO, which I think is a necessary step for this area of research. And second, the contribution of the RCT is phenomenal. This is the kind of research that we need to see more in S&T policy, of really looking at an intervention and the effect of that intervention. I would argue, as the paper does as well, that there are far too few truly causal studies within S&T policy, and this adds to the literature in that way in a very important dimension. So the results that I would see, women in the treatment group were 17% points more likely to receive a patent than women inventors in the control. And this is a slight flip in the narrative that's presented in the paper that focuses a lot on the women relative to the men. But I think it's very important to think about the women relative to women's experiences with or without the intervention, and in different kinds of samples in different units, which I'll talk about in a second. That the treatment effect for women is larger in fields where they have worse patenting rates. And I think this actually gets too far of I think it gets short shrift in the paper. It's mentioned, but it's not explored. Why is that happening? What's going on underneath these fields that help us to explain that mechanism? And then I think it is important that they found no significant difference in the patent scope granted to men and women overall in the treatment group. I think it's a really important thing that we're not solving one problem and constructing another here. So I know I'm getting close on time. I have a timer going, but I'll just go with 3 sort of critiques and classifications. One is more understanding of these examiners. So they talked about the PCP art unit, including 15 patent examiners at the highest seniority, which they admit pretty much exhausts the core. This is, a small group here. So they look at historic grant rate and effects of examiner experience. And they do see a relationship between those things and seniority, even though they say it does not have a significant effect on the outcome. But I think it's important to think about that in terms of scalability. If you move to mid-level examiners or entry examiners, what kind of results might we see? The other big thing is, are there gender differences in outcomes by seniority, which I think we've seen in some previous research? And then are there gender differences in seniority itself? Do these senior patent examiners look like the rest of the examiners across the USPTO? And that goes down to the next thing of that interaction effect between the gender of the examiner and the gender of the inventor, which is not explored in this paper. So there's a long part in the paper that's a response to Jensen and Cook saying, what would happen if we had blind review? I'm not convinced that this test actually addresses whether the examiners are responding to the gender of the inventor, rather than whether there's a correlative effect of the attributes of the applications related to gender. So given that we know so much about the positive effects of homophily in review in other areas of scholarship, I think that's an area that we have to investigate in this as well. I'd also be interested in whether there's a Hawthorne effect here. What is just the effect of training and selecting these examiners into the experiment, making them more aware of this situation? Does that have an effect of the outcome? I know I'm close on time, so I'll go through this quickly. I would love to hear more about the technology areas and any way we can dig further in that. Why is this happening? Why are we seeing this? Is just a statistical artifact? Those places where we had the biggest gap, it's easiest to see these kinds of massive growth areas. And then there's a small part in this that reacts to sort of the Koenig and other research, that there's a change in direction of inventive activity towards technologies that are beneficial to women. That wasn't examined in this. Do we have an understanding of whether this increase actually is related to technologies or inventions that may benefit the populations that are proposing them? And the last is just digging more into the sample. So we see that there's a higher percentage of women in this sample itself. Is that an artifact of their junior inventorship, the smaller micro entities, lacking proxy for legal representation? So trying to understand where we might have some confounding variables in this. So women are more likely than men to file a smaller micro, but what would be the effect if we actually just looked across all firms? As Gauri sort of implies in her study, there may be organizational, within organization differentiation in the kind of representation that's provided for men or women. So can we see this intervention having an effect on larger firms? And we see that there is a narrow patent scope overall for the PSP sample, and the PSP sample has a larger percentage of women. So what's actually the mechanism here? Is it really about first-time inventors? Is it those without legal representation that have this smaller scope? I think all of those things need to be teased out a little bit more. Kind of go through this quickly. I'd love to know more about the pro se intervention, what's happening now. The concluding parts of this article say that aspects of the PSP have been institutionalized at the USPTO and that they're given additional time. But was time the variable that mattered? Or was it the interviews? Was it the selection? Was it the training? Was that really the attribute that needed to be changed, just time? So I would love to know where people are going with that. And I think there's a lot of different areas where the USPTO has an option to do more studies. Is this scalable? Could you have opt-in options? How do we think about disambiguation and the role of the Success Act? And how do we think more broadly about intersectionality, looking at socioeconomic class, disability, and other relations? So I know I'm over time, so I will just thank you and I look forward to conversations.
Thank you, Cassidy. That was, you took a little longer, but Nick took a little shorter, so it all kind of worked out.
Perfect.
Excellent comments. Thank you very much. I'm not going to, I don't see any questions. There is a comment from Tim. Nick, take a look at that. And please, if anyone does have any questions or comments, don't hesitate to put them in the Q&A or the chat. Okay, very good. Now we're going to move on to Bernhard Ganglmair, who's at ZEW in Mannheim, the University of Mannheim. And his paper is Visibility of Technology and Cumulative Innovation, Evidence from Trade Secrets. And I see that we have Imke, his co-author, with us. Welcome. Good to see you. All right, take it away. You got 20 minutes.
All right, thank you. Thanks for having me. I'm sharing my slides. I'm also putting up a link in the chat window with a link to the slides for anybody who wants to download them and flip back and forth during the presentation. So this is joint work with Imke Reimers from Northeastern University, visibility of technology, cumulative innovation. We have something to say about patenting and trade secret laws. And we ask two big sets of questions. And I just move forward one slide. So if you don't see the second slide, please do yell at me. So we're asking two different sets of questions in this paper. In the first, we're interested in what is being disclosed in patents, or which types of inventions are kept secret by their inventors. And when we talk about types, we really mean are processes versus products. So this will be one of the key driving distinctions of inventions or different types. So which types of inventions are kept secret, or again, put differently, what is disclosed through patents when it's not being kept secret? And then using the insights from this first question, we then move on to a secondary question, or to our second question. And we're interested in welfare. This bigger question of, is too much trade secrecy or too much secrecy, is it bad for welfare? And the way we look at this question is we try to implement it through the legal strength of trade secrets protection. So what we're really asking is too much protection of trade secrets bad for welfare? So these will be the two types of questions, the two sets of questions we're asking in this paper. And I want to give you a quick summary of what we are doing. I'm not going to go into the great details of everything. So sometimes there will be a little bit of a teaser. So take a look at the paper and please feel free to contact us if you have any further questions. As for the first type of question, namely what is being disclosed, we could really think of it as an inventor facing the following decision. Say an inventor has a new invention at hand. And here I have two different types. One here is a machine for cutting the fronts and backs of violins. So you just invented a new machine. And a different invention could be the process of doing something. Here I have a patent for the process of treating wood for the manufacture of musical instruments. So as an inventor, I have this option. Okay, I can take my invention, I can put it into the patent system, I can file for a patent. Or, well, alternatively, I could keep it a secret. And for that decision, the legal protection or the institutions that matter will be important. If I file for a patent, well, in the US, it's a federal statute. I can file for patents for what is patentable. There are different things that can be patented and other things that cannot be patented. I'm granted exclusive rights over 20 years from the date of filing. Trade secrets in the US are traditionally driven or governed by state law. And anything that's of potential value can potentially be a trade secret. I don't gain exclusivity. If somebody else reverse engineers my trade secret, they can use it. If somebody independently discovers what I try to keep as a trade secret, they can use it. But trade secrets protection, in a sense, is potentially indefinite. What's critical for our paper or for our work is that patents protect against unlicensed use, whereas trade secrets only protect against what's called misappropriation. And I think the simplest case of misappropriation is somebody steals your invention, your trade secret, through fraud, for instance, or an employee walks away with your trade secrets and then discloses it to one of your competitors. A big advantage of trade secrecy is you get to keep something secret. A big downside of patenting is you have to disclose it. So for an inventor, these different features of the institutions will matter whether or not they're going to go for a patent or a trade secret. And this question of secrecy and can I keep it secret is something that's at the core of our paper. So what is really a trade secret and how should we think about legal protection? Before we go any further, a trade secret can be a lot of things. Anything that a firm produces or collects and then it tries to keep to itself. A secret barbecue sauce, a customer list, Edison's 10,000 ways that something doesn't work. Or, and we would like to make this a true decision between patents and trade secrets, a specification of a machine or production process, something that could also be patented. What does legal protection of trade secrets mean here in this context? Well, for instance, if actual intended use is required for trade secrets protection, then that's a limitation of the protection. If I actually have to use what I'm trying to keep a secret for me to be afforded legal protection, well, that's a limitation. Also, if there's no punitive damages multiplier, if damages for misappropriation are actually relatively low or do not come with punitive damages, there's less of a deterrent. So that's also weaker trade secrets protection. And we will use a trade secrets protection index that was constructed by Ivan Peng in another paper to measure the degree of legal protection of trade secrets. And when we talk about the legal protection from trade secrets, we'll just vary that. We'll take that as a parameter, as that index parameter. We'll vary that between 0 and 1, or the index will allow us to vary it between 0 and 1. And we will assume that patent protection is, we take that as given. And we assume patent protection is, in a sense, stronger than trade secrets protection. But the legal protection from trade secrets, that will vary over time and will also vary across states. And it's that variation over time and across states that we'll explore and exploit in our empirical analysis. The way we want to think about the second question, so the first question was all about an inventor deciding patent or secrecy. The second question is about welfare. And the way we incorporate or implement this in our paper, think about it in a paper, is the following trade-off. Higher trade secrets protection will give higher ex-ante R&D incentives. Keep patent protection fixed. If you protect trade secrets more, well, at the margin, firms will have stronger incentives to invest in R&D. Well, if that's the case, if we see more initial inventions, we also have more potential for follow-on innovation. So that's good. That's green here. But as what we'll show in our first question, stronger trade secrets protection would also result in less disclosure of things that are otherwise not visible. And if there's less disclosure of what's called non-self-disclosing inventions, well, then there is less to build on. So there's less potential for follow-on innovation. And we'll also get a bit of a larger deadweight loss from trade secrets protection as we increase the level of trade secrets protection. So that will be the downside in this welfare analysis. So we have the positive and then negative effects. And the way we eventually try to make this happen is in the 3-stage R&D model, where at stage 1, an inventor sees a potential invention and simply weighs the cost of R&D against the expected payoffs of developing that invention. And all the inventions that are realized, we'll call them the realized inventions. For all the realized inventions, our inventor now has to decide, do I keep it a secret or do I put it into the patent system? Do I apply for a patent? The big question an inventor will have to ask is, or one of the big questions, can I enforce the patent? Can I actually monitor the use of my patented innovation by others? Because if I cannot monitor it, if I cannot detect, if I cannot see others using my invention, I cannot enforce that patent. And the flip side of this question is, can I enforce my secrecy? Is what I'm trying to keep secret actually secret, or can others immediately see it when I use it myself? So there's this notion of visibility, or this notion of self-disclosing of an invention. And that also matters for follow-on innovation. The probability of follow-on innovation now at stage 3 is driven by 2 things. One is, how strong are the barriers to access? Say I have a patent, can others actually use my patented invention to build on it? Do I grant them access? And how strict are those anti-commons effects on patents? The second question, though, is, if something is not disclosed in a patent but kept as a trade secret, well, how much of that is actually visible for others to use for follow-on innovation? So the question of follow-on innovation will be important in the sense of, am I allowed to see, or am I allowed to stand on the shoulders that I want to stand on? And can I actually see the shoulders that I want to stand on, as in the context of cumulative innovation? So visibility is vital for patent monitoring. Without it, I cannot enforce my patent, but it's fatal for secrecy. And here's a quote from a practitioner's guide: a patent claim whose infringement is very hard to discover is a claim with low or no value. So that just illustrates how important this idea of visibility is. And Strainberg, a legal scholar, instead of using terminology visibility, she calls this self-disclosing inventions. It's those inventions that would self-disclose them by use. Visibility is difficult to measure. And the vehicle that we use to proxy for visibility is process or product patents. We argue that processes are on average less visible than products, and having information on process patents as opposed to product patents, we can look at this visibility using patent data. All right, so what is our approach? What does the paper do? And then I'll really just show you a few 1-2 tables and a couple of pictures, and those are our main results. In step 1, we ask this first question: does stronger trade secrets protection affect what is disclosed? And our data source is the following. We use US utility patents, and we have indicators for the type of claims that are in those patents: process claims or product claims. So we can count them, that we can aggregate that to the patent level to say something about, is a patent more likely to cover a process or more likely to cover a product? And we'll use a binary indicator here, saying that a patent is either a product patent or a process patent. And the second data source we use the Trade Secrets Protection Index constructed by Ivan Peng. And the Trade Secrets Protection Index gives us state year level variation of the legal protection of trade secrets. And I have a few more words to say about that in just a few minutes. Step one is reduced form. So here we provide reduced form estimates, and we show that we document less disclosure of less visible inventions, meaning we document less disclosure of processes. Processes are less likely to be disclosed, or processes are less likely to be patented once trade secrets protection increases. Inventors are more likely to keep those secret because those will be hard to enforce as patents anyway. So that's step one. Step two, we then start looking into this welfare question. And we ask, how does a reduction of the disclosure affect follow-on innovation and overall value? And for that, we calibrate this three-stage cumulative innovation model, and then we vary the level of trade secrets protection. So this is our counterfactual analysis. And then we look at what happens to overall value, what happens to welfare. In this step two, we take a very simple approach. We assume that the visibility of these potential inventions, those that an inventor draws out of the hat initially, those initial ideas, we assume that those are uniformly distributed. A very simple, bare bones assumption, just to get a little bit into the mechanics of what's going on in this three-stage model. And then the third step in the paper, we then develop a structural model. There we go back to the data to then estimate these distributions for visibilities. And using the size of the causal effect from step one, from the reduced form estimates, we first estimate distributions of the realized inventions, those that we see at stage two. And when I say estimate distributions, I mean the distributions of the types. So what's the distribution of processes and products of the realized inventions? And for each of these, what's the distribution of their respective visibilities? Then using these distributions for the realized inventions, for some given R&D cost, we can then recover the distributions of the potential inventions. And we then use those again for welfare analysis, and then look at different effects for processes as opposed to products. Okay, one last word on the trade secrets protection. So here we use as a natural experiment the Uniform Trade Secrets Act as a quasi-natural experiment. The Uniform Trade Secrets Act gives us exogenous variation in trade secrets protection. It's published by the National Conference of Commissions on Uniform State Laws, and states can voluntarily adopt it as a template to change their rules governing trade secrets from common law to the Uniform Trade Secrets Act. It's meant to harmonize and clarify state trade secret laws in a number of different dimensions. Here, two examples. Virginia, for instance, dropped the use requirement, and it increased punitive damages multipliers from 1/2 to 2. So for Virginia, those two changes meant a stronger protection of trade secrets. The Trade Secrets Protection Index was constructed by Ivan Peng, and it measures the US state year-level strength of trade secrets protection with changes around state-wise adoption. That's what we eventually exploit in the empirical analysis. So 3 steps, quickly our results in the last 5 minutes. In step 1, does stronger trade secrets protection affect what is disclosed? In the paper, we have a little theory model for that stage 2, for this decision of patenting versus secrecy. And the prediction from that model is that the share of process patents, or the probability that a given patent is a process patent, is decreasing as trade secrets protection increases. So as you make trade secrets more interesting for inventors, they're more likely to keep their processes out of the patent system. Our empirical strategy, we exploit the staggered adoption of the UTSA. Our dependent variable is the patent type. Is it a process or a product? And our independent variable of interest is this trade secrets protection index. And we expect a negative coefficient on that independent variable of interest. And that's what we see. So we run this for a number of different specifications and models, controlling both for patent complexity as well as patent values, state fixed effects, year fixed effects, also USPC main class fixed effect, for a variety of different models. And we find a negative effect of stronger trade secret protection on the probability that a given patent is a process patent. So we see less disclosure of what's likely hidden, processes being less visible. We see less disclosure of those processes once trade secrets protection increases. The UTSA overall leads to a mean decrease of about 2% of the probability that a patent is a process patent. We were worried a little bit about the timing. Is this a gradual effect or an immediate effect? So we run an event study design, and we see that first, there was no obvious pre-trend in the probabilities that patents include a process. And second, the coefficients suggest that there was an immediate and lasting negative effect of the UTSA. So what we see here is the coefficients of the effect, or what we see here is the effect of the UTSA interacted with a time indicator leading or lagging the respective change, or the respective adoption of the UTSA. The effect is not homogeneous in the sense we do see that the effect is stronger for individuals and small firms. And we also see that the effect is stronger for discrete technologies as opposed to complex technologies. Discrete technologies, examples being the chemical industry or the pharmaceutical industry. We ran a number of robustness tests. We checked identification a little bit. Here, I just show you those that worked. Those that didn't work, of course, never made it into the slide. So we're quite confident that the results that we have follow through. All right, now 3 minutes, just our welfare question. The big question of what does this reduction of disclosure do to overall welfare, to follow-on innovation and the overall value? So step 2 gives us the model calibration with these uniformly distributed visibilities. And assume that there are no R&D costs, then we'll see a negative effect. Stronger trade secret protection has a negative effect on welfare. We can split this up, the overall effect, into the value that's associated with the initial innovation or the initial invention and the value associated with follow-on innovation. Initially, we see less follow-on innovation because less is disclosed. So that's the dashed line. And the ex-ante incentives are ineffective. We said stronger trade secrets protection gives stronger incentives to invest in the first place. But if there are no R&D costs, those additional incentives don't matter. So they are not effective. So we see both for the the value associated with initial innovation and the value associated with follow-on innovation, it's negative effects here. If we introduce some R&D costs, the picture is a little different. Then we may see positive effects. We can see a stronger protection can indeed have a positive overall welfare effect. Let's again split this up. The solid line is the value associated with the initial invention, and the dashed line is the value associated with follow-on innovation. We now have a negative effect on follow-on innovation, and if that prevails, we still have. The dashed line shows down. So stronger trade secret protection reduces the value associated with follow-on innovation. There's just less that's visible for others to use. But now with R&D costs, the ex-ante incentives can more than offset the negative deadweight loss that we have associated with the initial invention. So we can now actually see a positive effect of trade secrets protection, because with stronger trade secrets protection, we boost those incentives to invest in the first place. If we put things together, we find that optimal protection increases as R&D costs increase. So if we do this for a lot of different values of cost, what we find is that optimal trade secrets protection, well, it depends on the cost of R&D. It increases as we get higher R&D costs. And that rationalizes, for instance, trade secrets protection rules in the state of New York. So a higher cost should be associated with a stronger legal protection of trade secrets. What we also find is that if you increase the weight, 1 minute, if you increase the weight of follow-on innovation, if follow-on innovation gets more important, then trade secrets protection should optimally be lower. Because follow-on innovation being more important means that we distort more of that as we increase the level of trade secrets protection. And we can do the same exercise here, which is change the relative weight of follow-on innovation, and we get a decreasing graph here. So as follow-on innovation becomes more and more important and bears more and more weight, optimal trade secrets protection should be low. I'm going to skip the third step with the results of the structural model and just quickly summarize. Namely, we look at we argue visibility matters for the patenting trade secrecy trade-off. Trade secrets matter for the patenting versus secrecy decision. Both matter for disclosure and follow-on innovation in the ways that I've tried to argue. What we do now is we add costs to the picture to get a non-trivial effect of trade secrets and welfare. Now, is it bad for welfare? Depends on the R&D costs. And this is the slide I want to leave up here just for one moment. Why does it matter? Because we think we need more research on secrecy and trade secrets. A lot of innovation literature is on patents because that's what we can see. We don't really see trade secrets that much, and make no mistake, we study trade secrecy using patent data, but I think we need more research on this simply because secrecy is an important tool in an IP manager's toolkit. Thank you.
Awesome. Thank you, Bernhard. Okay, now we have our discussion by Mike Teodorescu, who is at Boston College. And Mike, you have 6 minutes.
Hey, thank you so much for inviting me to discuss the paper. It's fascinating work. And well, I'll just give you a little bit. Well, I think there's more work needed in this field. Just as a reminder, so patents do force you to disclose, but give you that limited monopoly over the rights. But not everything is patentable. So I was thinking of some other examples of essential company data like customer Rolodexes, market modeling, techniques that didn't work in making the product. So you could try to manufacture a product and fail, and that information is valuable in terms of R&D. So some things you cannot really patent, but are still valuable. So while trade secrets are ideally never disclosed, which could give you the infinite term of protection potentially, and are much broader in terms of the value of the information, there's really no guarantee against theft, right? And the remedy against theft is fairly limited. And a key, I think, distinction between the patents and the trade secrets as alternatives is that if somebody reverse engineers your patented invention, then you are still protected, whereas that's not the case with trade secrets. So kind of the big picture questions that were discussed in this paper were: is too much protection for trade secrets bad for follow innovation? Which kinds of innovations should be kept secret? Is there kind of a strategic behavior in choosing the kind of innovation based on if you're an individual, small business, or large firm? And is increasing trade secret protection bad for welfare? So in terms of so there are the two propositions. I just want to focus on two types of visibility. So there's disclosure visibility, which is the ease of observing someone else using your invention, and there's secrecy visibility, which is the ease of somebody else observing you using your secret invention product. Those are important in the formal model, which I'm not going to go over because of time. But essentially, there are 3 steps, right? There's a cost of R&D versus expected payoff. Then you have to choose whether to disclose or keep secret. And then there's the follow-on innovation probability somebody will invent around you. Regarding the first one, I thought it was a pretty strong assumption to model that you can know what is the private commercial value from exclusive use. I would argue that at best you can estimate the potential market, but that's actually unknowable ex ante, especially if the technology is something that doesn't yet have a market. So if you have breakthrough innovation versus incremental innovation, that could be an additional step that you might have to consider as a 4th parameter after the parameter V in the tuple to discuss, to decide whether or not you want to disclose or keep secret. In some cases, the measure of experience of the innovator in market for the product might be able to help you proxy for this. It's interesting the paper is focusing on process patents. Let's focus a bit on definition. A process patent is such if at least one of the independent claims is a process claim or a product by process claim. I was curious if that's done at the publication level of the claims or the grant level. I'm also curious if you've looked at the restriction elections. So if you have both process and product claims, the patent, sometimes the examiner might require you to elect a path of the set of claims, especially if you have multiple inventions, concurrent inventions, so to speak, inside the patent application. Sometimes if you have a process claim, that might result in a restriction. I'm also curious to see if instead of having only one claim of the process type, you run a robustness check looking at, say, overall word counts that relate to process versus product, degree of overlap of the process claims with the specifications, if they're like a minor part of the patent versus a substantial part of the patent description, and the degree of continuations from the parent application. I'm also curious if you looked at the time to grant and how that might be affected by the process claims, i.e. if the process claims somehow result in weaker patent applications or they take longer to prosecute, more debate around them. I noticed you remove business method patents, which could be considered a subset, and I completely agree with that. I just thought that maybe that there's something more there. And instead of looking at independent claims, I was thinking you could look at the breadth of the claim tree under the process versus the breadth of the claim tree under the product independent claims. Since patent applicants have to pay for over 20 claims in the US at least, whether they choose to develop more of the process claim tree versus the product claim tree may indicate if they believe there's more value within one portion or another of the patent application. I was curious if you have some kind of intuition why the number of process patents has increased from 30 to 60% over the last of the 30-year time span you looked at. I thought that there would be a lot of value in adding some additional controls related to claims from the paper by Ellen Marco and co-authors on patent claims and research policy. I thought there was a little bit of either a confusion or type on table 1 regarding number of claims and number of patents, so perhaps a little more explanation there. Also for the missing generality, originality values that you don't have them for every patent. There is this great new data set, ipprog.io from Getan. I was curious if you looked at linking the product patent data with it. That data set looks at patents in actual products in use. On disclosure, I wanted to comment that pharma patents, which are used in the paper, are an example where reverse engineering can result in failure of secrecy, but also there are other barriers to entry, especially for pharma, that would make trade secrets obvious. So, for example, in order to get regulatory approval for a drug, you have to go through an FDA or CE process, which would require to disclose the formulation as well as clinical trial data and then vast amounts of information about the product. So trade secrecy in this particular case may be impractical. So in some fields, trade secrecy, especially where regulatory burden is high, trade secrecy is may actually be impractical. It would be interesting to look further at, and I think I'm almost out of time. It would be interesting to understand better the debate you reference to US versus EU. I thought that your exogenous variation across states is really amazing. I think I will stop there and share you the rest of the slides.
Wonderful. Thank you very much, Mike. I've been so impressed with everyone so far today, and now we're going to move on to our next paper with two excellent economists. It's Tim Simcoe from Boston University, and it is Cesare Righi, I believe, is also here this morning or this afternoon. They're going to talk about patenting inventions or inventing patents, strategic use of continuations at the USPTO, and that'll be followed by a discussion by Gaetan de Rosenfoss, who's at EPFL in Switzerland. So, Tim, please take it away.
Thank you, Andy. I note that Bernhard's innovation of posting a link to the slides was self-disclosing, and so I have appropriated it. I'm going to try to share the screen now. This is joint work with my friend and co-author Cesare Righi, who is now at Pompeu Fabra. And this comes out of some work that Cesare initially started in his dissertation. So this paper is entitled Patenting Inventions or Inventing Patents, Continuation Practice at the USPTO. And if you'll pardon a pun, I'd like to start by talking about a continuing controversy. Okay, and to understand the continuing controversy, you have to understand a little bit about what a continuation is. A continuation application is a type of US patent application where the applicant applies for new claims based on a prior disclosure, keeping the priority date of an earlier patent application. Why would that be controversial? It's controversial because it sort of flips the normal narrative that I think most people have in their heads with the patent system, which is an applicant applies for a patent that contains a disclosure and also sets out the claims that define the boundaries of their property right. And then along comes someone who might infringe it. That could be contested, taken to the courts, and so forth. With continuations, there's at least a possibility that those two elements of infringement and claim drafting get reversed, right? An applicant can file an initial patent that makes its disclosure. Then along comes some instantiation or embodiment that may or may not infringe. And then the claims are drafted after the infringing occurs, which sort of creates this possibility of sort of drafting your claims so as to guarantee the infringement, and worries about expanding the scope of the property right in ways so as to read on follow-on innovations. We are not the first to think about this or express those concerns. If you go back to 2003, the FTC talked about continuation practice, creating possibilities for opportunistic behavior by applicants. Around the same time, Intel talked about applications that revoke from the public domain, what the public thought was freely available to all. In 2007, the PTO actually passed some rules to try and curtail continuation practice, or I shouldn't say passed, proposed, and those were essentially fought back and abandoned. And there's evidence that this kind of thing still goes on. There's a remarkable article by some authors, or an author from Rambus, that sort of describes actually how it's a very useful strategy. They say, we keep continuations open so that we can craft focused claims that specifically read on competitors' product implementations. And continuations played an important role in a recent antitrust case in the pharmaceutical sector. So this isn't a thing that's kind of limited to information and communications technology patents. So continuations are controversial. There is a case for them. I think the case for continuations is best laid out in a theory paper by Carmen Matutes and Pierre Rejebeau from the mid-90s, where they talk about when some kinds of invention are ambiguous in some sense. There's a lot of scope for follow-on. It's unclear exactly how they will be used at first. So these are pioneering inventions with a lot of initial uncertainty. Continuations may encourage earlier disclosure by the patentee because it gives them an option to draft their claims later when some of that uncertainty is resolved. And the other part of the case for cons is that it defers examination. So low value claims that in a world without continuations, an applicant might feel compelled to sort of lard their patent application with claims up for everything. Those might get abandoned without ever being examined, which could be efficient. The case against cons, I already sort of laid out. There are these worries that the ability to claim after potentially infringing instantiations hit the market raises concerns about whether follow-on inventors get sufficient notice, or whether late claiming removes those embodiments from the public domain that were in some sense in the public domain previously. There's an observation that Herb Hovenkamp makes in his book with Christina Bohannon, which is essentially that if we think patents are mainly there to provide incentives to innovate, it's not clear that the unanticipated uses of an invention contribute to those ex-ante innovation incentives, because in some sort of tautological sense, you didn't know you could use it that way. And then there's sort of a case against cons that I won't get into, but which is interesting. I think it presents some challenges for workload management at the PTO based on conversations I've had. Sort of continuations always go back to the initial examiner, which has some obvious efficiencies, but may make it challenging for balancing examiner workloads and maybe create opportunities for sort of exchange between applicant and examiner when examiners get kind of full credit for doing rework on a particular kind of application. So the bad news, in some senses, we're not going to completely resolve this today. This paper is not going to tell you are cons good or bad for innovation. Where our contribution is going to be is slightly more modest. We're going to try and provide some hard evidence on late claiming, right? Is it the case that we see this kind of behavior of expanding the claims of the patent or trying to draft the patent onto a product innovation in some sense after the follow-on innovation occurs? Continuations are common, right? I mean, 15% of all applications in 2018 were continuation applications, but it's hard to know whether those are instances of late claiming that create notice problems for a couple reasons that should be familiar to anybody who does work with patent data. One is it's hard to link patents to potentially infringing technologies. This is like one of the big challenges of all economic empirical work with patent data is how do you map the thing onto a product or something that might infringe? And then the other is that the story that we're telling about notice failure or potential holdup is, in some sense, there has to be a commitment to that design, right? Like if the claims read on an infringing design, but then you can sort of immediately get around those claims, there's not really a problem here. So you need to observe something about when the design gets locked in. And what we do in this paper is we take the continuation question to standard essential patents data, because that's a promising setting for solving these two measurement challenges. Right? With standard essential patents, which are patents that get disclosed in the process of creating compatibility standards, usually for information and communication technologies, right? The modal technology you should think about in this paper is a cell phone, the chip that makes the radio work in a cell phone. In those settings, there are disclosure policies that create a link from the patent to the standard. And the standard is what is, sort of induces infringement in a variety of products. And there is a date when the standard is published, which we take as a proxy for lock-in, sort of at that point, probably a little before that point, honestly. The design of the standard is fixed. And so in some sense, the incentives to begin tailoring your claims so as to have them be infringed by a standard are going to increase. Okay, so to summarize the results, we show that at least for these standard essential patents, what looks like late claiming, or what we call late claiming, is very common. In fact, in the universe of US standard essential patents or declared standard essential patents, more than half of those patents are filed after the standard is published, which looks odd, at least to me, right? It does invert the usual narrative of infringement following claims. And if you think about it this way, right, the probability that conditional on being a declared essential patent and a continuation, the probability that the patent is filed after the standard is published is 85%, 84%. Right, so at least in these areas where there's an opportunity for late claiming, in this context, it seems quite common. Okay, so to unpack that, we then sort of exploit timing. We go look at the standards process and we show that after the standard is published, there's a 80 to 100% increase in the probability that an initial application leads to a continuation. We find that effect is bigger for more lenient examiners. So in some sense, the story is one where the applicant gets a draw, looks at the examiner, and for those with a high allowance rate, they're much more likely to file these post-standard continuations. The effect is bigger for companies that are sort of more engaged in patent licensing as opposed to those that are sort of downstream implementers of the standard. And then we try a few ways to produce evidence that this is tailoring of claims or broadening the scope of the patent to read on the standard. This is more challenging from an empirical and a measurement perspective, but so one thing we were able to do is show that these post-standard continuations lead to more non-statutory double patenting rejections, which is for reasons explained in the paper, we take as a proxy for broadening the scope of the claims. We do an exercise with the language in the claims. We show that for pairs of patents that have parents where the application occurs before a standard is published, the language in the claims has fewer word commonalities than for those same pairs of continuation applications filed after the standard is published. So in some sense, there's a convergence in the terms used in the claims of patents after the publication of the standard. And we show that finally, these post-standard SEPs are more likely to be litigated. Okay, so just the later filed patents disclosed for any particular standard, including the ones that are filed after the standard is published, are the ones that are more likely to be asserted in court. So that is the paper, and I've taken about half my time, I think, just to set it up. So let me try to go quickly through a few of the results and just hit high points. We contribute to a bunch of prior literature that I won't spend a lot of time on. Our data, there's two basic sources. One is the Searle Center database, a public good produced by Eustace Baring, Kirti Gupta, Tim Pullman, and Dan Spulber. It contains lots of information on declared essential patents from many different standards bodies. Again, the big one in this data is the European Telecommunication Standards Institute. You should think of a lot of this having to do with cellular standardizations. And then all of the great data produced by the Office of the Chief Economist. In particular, here we need data on the prosecution process, so the patent examination research data set is a biggie for us. The claims as well. Okay, this in some sense is the first result, which I already hinted at. Basically, this table shows us a couple of things. The first is that if you look at the size of the bars that are labeled SEP, you'll see that standard essential patents are far more likely than typical patents from the same computer and communication TCs and art units to be filed as continuations, right? So in some sense, we know standardization is a setting that creates these opportunities for late claiming. And here we see lots more continuations, right? So there's a sort of a selection there into continuation filing. And then the size of the black, the darkest shading on the bars labeled SEP show us that conditional on being a continuation and a SEP, there's a very high probability of being filed after the standard is published. Okay, so to get at sort of a causal effect of standardization on filings, or to try and move in that direction anyhow, we estimate diff and diffs regressions. So we compare SEPs versus non-SEPs from similar technology areas before and after publication of the standard, with fixed effects for things like technology class, grant year, kind of an age trajectory for the patents. You know, the unit of observation is a parent application filed in a particular quarter. So we take the parent and we watch to see if a continuation ever happens on that original application. And so we have two control groups. One sort of basically matched on technology, and the other also does some pre-trend matching on the number of initial continuations, which is either typically 0 or 1. So here's what we find. You know, basically there's a gap. You know, sort of standard essential patents are more likely to generate continuation filings even before the standard is published, but that gap increases afterwards. And then if you match so as to sort of cause the initial gap to go away, there's a pretty big increase in continuation filing rates immediately after publication of the standard. Whoops. You can put that into a regression format, and you know, sort of the regression coefficients tell the same story. I think the more interesting thing to do then is to interact, as I said, with something like how lenient or is the examiner, like what is their allowance rate? And we see that a 1 standard deviation increase in the allowance rate of an examiner who is filing one of these, who is examining an initial parent application and who therefore has a very high likelihood of being assigned the continuation. Those more lenient examiners are much more likely to see a continuation filing on an initial application after the standard issues. And so in some sense, I think this is consistent with a story where the applicant gets a draw, has a sense of whether the examiner is likely to grant their new claims or not, then sees what the standard is, and if they have a good examiner and an opportunity to draft their claims so as to read on the standard after the fact, they do, or they're at least more likely to. Let me briefly talk about claim drafting. There's a question of, are the continuations used to broaden claim scope? Well, one way to try and get at this is to use what's called non-statutory double patenting rejections as a proxy for broadening your claims. This was a suggestion that Jeff Kuhn made to us, and so we're grateful to him for it. The way that works is that a non-statutory double patenting rejection issues when the continuation application is anticipated by the parent application, and so it's a sort of administrative type of rejection that the examiner can issue and that can be overcome by basically just filing a notice on the part of the patentee. But it tends to sort of suggest that, oh, sort of I'm taking a claim and broadening it because the claim in part reads on the claims in the prior parent application. And we see that for SEPs, after a standard is published, there's about a 7 percentage point or a 15% increase in the likelihood of these non-statutory double patenting rejections. Another exercise we do is to look at claim similarity. We do this using the Jacquard index, and we borrow code from Sam Arts and co-authors' work that's using Jacquard index to look at the disclosure in patents. We apply it to the language in the claims and basically find what I tried to describe earlier, which is that if you take a pair of patents that have parents filed prior to the standard and you construct a similarity measure for pair K during the pre-standard period, okay, the Jacquard comparing within this pair of patents, and then that same pair has a pair of continuations filed after the standard, the early claims are more likely to be similar to each other than, or less likely to be similar to each other than the late claims, right? So there's a convergence in the language in the claims after the standard is published. To be clear, that many people think that's kind of a natural evolution, right? If we know what direction the technology is going, it's normal for the claims to converge. Our point is just that it likely has the effect of bringing these patents closer to being essential. And then the last thing we do is we look at litigation, sort of our litigation results. We basically do it two ways. We say, is a SEP applied for after the standard was published? If so, we see about a 50% increase in the probability of that patent being asserted in court, right? The mean litigation rate, as in most samples, is small, here about 2%. It goes up to about 2.9 if it's a SEP after the standard. And then we can use the continuous variation. We can construct something called filing lag. Filing lag is the date of the priority date of the patent minus the date when the standard is published. So positive if the patent is applied for after the standard is published. And so every year of filing lag raises the probability of patent assertion by about 1/4 percentage point. So I think I've summarized the paper. Talk briefly about sort of reiterating what we did. We provide evidence of late claiming via continuations in the context of standard essential patents. Okay, we show that a large share of standard essential patents are actually filed after standards are published, and that those are mostly continuations. In a diff and diffs framework, we show that standardization produces an increase in continuation filings that's larger for lenient examiners and for firms that are more likely to try and monetize their IP. We think that there's lots of opportunities for further research in this setting. One is to look at continuations in other contexts like pharma, to look at tools for deferring claim drafting that might be used in other jurisdictions. This is a US paper, but divisionals and deferred examination are tools that might be used in Europe or elsewhere. To look at delays more generally, not just through cons, and to, I think most importantly, think about trying to get at impacts on downstream innovation in a more direct way than we do here. That being said, if you think that this is a potential issue, it's worth thinking about policy tools for addressing opportunistic behavior through continuations. There's a lot of different ways that have been thought about to do this. You could cap, for instance, the length of a chain of continuations. In some cases in our data, we see continuations of continuations of continuations of continuations, and so that claims are being drafted 15 years after an initial patent application using a priority date, that's now 18 years in the past. You could cap the length of those chains. You could change fee schedules around continuations. I think an idea that the FTC proposed in 2011 is particularly promising in this particular setting, which is you could create intervening user rights so that, if a standard setting organization publishes a standard, that becomes prior art, at least relative to the claims in continuation filed after that. And these are things that could be done, that fix might take legislation, but, standard setting organizations could make their own efforts to get at this issue as well. That's all I have. Thanks so much for inviting us to share this today. And I'm looking forward to Gaitan's comments.
Thank you so much, Tim. That was excellent. So Gaitan is going to have 6 minutes, and I apologize. I'm going to talk about a trivia night, but it has nothing to do with your paper. I wanted to mention that later, but let's stay focused here and Gaitan, take it away.
Thank you very much, Andy, and thank you very much, Tim and Cesare, for this paper. All right. I love the title. I actually do love it's really, really meaningful, and actually love the paper as well. And so I think the paper lives up to its title. It's obviously a very advanced paper with lots of efforts, lots of robustness tests, lots of different data. It's a relevant issue. The evidence is convincing, and you have extremely interesting extensions for someone like me who likes, nice subtleties and features about the patenting process. I think, the business model, the examiner leniency are actually super interesting. So that makes my job as a discussant, of course, very challenging. Nevertheless, I have a couple of comments. The first one I must admit is actually more, comes from version 12 of your paper, not from version 13, because I think you've made quite a difference between the two. And I think in the first version, in the 12th version, I think that the paper really had too much an anti-continuations focus, and kind of was too heavily biased. But nevertheless, I think some of these comments actually remain. You have two measurement challenges. The first one is to link patents to infringing technologies and use SEPs for that purpose. And you also need a clear milestone in technology development. And for that, you use the standard publication events. And so, these are, and that's not a rhetorical point. This is actually, to me, like an important argument, because these are challenges for the econometrician, but there are actually also challenges for firms, because if firms cannot observe point number one and point number two, well, then continuations are unlikely to be used opportunistically. So that makes me wonder, is it actually it's maybe the best setup, SEPs and standards to observe this phenomenon, but is it also maybe the only one? So you discuss about continuations in general and why they might be good or bad, but that feature that you describe here and the identification strategy is really almost specific to SEPs and standards. I couldn't really think of a different setup where we could observe these two phenomena so clearly, or overcome these two challenges, which means firms actually are facing the same issue as well. And in addition to that, standards is a really particular case where actors need to coordinate. And so where this incentive to opportunism is likely to be exacerbated. And so my recommendation was here, can you make a better case that the problem is bigger than SEPs? You don't have to make that case. Actually, I think in your new version, if you just provide evidence of late claiming, that might be enough to contribute to the debate. But of course, if you can think of other setup with this opportunism might be exacerbated, I think that would be another, that would increase the generality of the finding. On question number 2 on the policy consideration, it's kind of a related point, but I felt that the discussion on policy proposal was rather short, and in fact your paper has lots of very interesting insights. For instance, how about at least discussing the point in your conclusion of systematically changing examiner at each continuation? Because we know that firms learn about leniency. So how about we redraft the examiner at continuation? So maybe that's worth discussing. In the fee schedule, you mentioned the fees, but you don't discuss too much what we could do about fees, maybe increasing fees for each new continuation. So kind of exponentially increasing fees for every new continuations. How about flagging SEPs as such that they might receive or not, but a more exacting treatment by examiners? So I think the policy discussion could be broadened here and enriched in your paper. But then I'm also wondering, okay, is there an issue? And here the devil advocate in me would say it might actually be welfare improving to have patents that are more closely aligned to the standard. There is less uncertainty, there is reinforced essentiality of each patent. So is it really such a bad thing? And the part on litigation, which you added from 12 to 13, was actually a very welcome addition. But it's not super surprising because we know that in all likelihood, these patents are likely to be more valuable. And we know that more valuable patents are also likely to be more litigated. So I'm not too sure how I should think about this higher litigation rate here. I have no solution, but at least that's the feeling I had. That's another, it's probably more subtle point, but I'm convinced that there is an effect. Looking at the data, it's obvious something is happening, but I'm not convinced that the magnitude is actually estimated accurately. And it all boils down to the way you have defined your original sample, because you sample on families that are still active or pending at the time of publication, right? So in a sense, it's almost certain. So I don't know what's the average timeline between SEP, the original filing of the priority document, and the standardization. But if they are still filing at the time of the standard document is published, it's most likely because they already had continuations, or it's because we now firm kept it open to have continuations or to file continuations. How about you just sample on SEP's family, regardless of whether they are still pending at the time of examination? Because at the end, the beta, the main beta coefficient that you have, to me, captures the probability of filing a continuation, almost conditional on a continuation being filed eventually. And we can discuss that offline, but I think that's an important point. I also wonder, again, in trying to estimate the magnitude of the effect, how clean is the control group? So do we have SEPs in the control group, which actually also is another way of asking how comprehensive is the SORL database? Does it include all of the SEPs or not? I mean, related patents related to other standards as well. I think it's worth discussing. Just that we know that we have a clean control group. Another suggestion, which I think is more promising than the current use of textual data that you make. So far, you show that there is convergence in patent text, and I would actually argue that convergence is not necessarily a bad thing. It might increase clarity or whatever, but what you could show with the data is actually you take the same treatment and control group that you have and before and after, and you just measure how different the original patent is from the continuation for both treated and control group. And I would expect that we see more divergence in the treatment group, so the SEPs, as opposed to the control group. So here, all of a sudden, the story doesn't become one of convergence, but almost one of not convergence between continuals, but divergence from the original to the continuation. And that's something you could easily test. And in fact, I would actually argue in favor of using the Google similarity data, which you can download from the Google public patent database, because the measure is kind of superior to what exists so far, in the sense that they measure not only keywords or text-based similarity directly, but also include concepts. So you'll have similarity in concept as well. So you have a more powerful measure of text similarity. So I think that's one direction in which you could go to actually show a divergence, in fact, from the original document, which would be more consistent with your narrative. An idea for a follow-on paper on continuation would be to use the iProduct data, this data on patent products. That would be the positive or the bright side of continuals, because we have actually make some claims here about the role of or the value added of continuations, but we could actually test them with data on patents to products. I have a couple of other and more minor comments and suggestions. I will share the slides and I will stop here in the interest of time. But congrats for the paper and good luck.
Thank you, Gaetan. That was a very good discussion. This paper's been around a little bit of time. It's been able to be discussed by a few people. So I do really appreciate the added additional value onto that. And it's such an awesome paper. Our AV tech is very kind to us. She said that we can have a few more minutes. She has to jump off of this. So let me just, first of all, I said that I would make a plug for the Society of Government Economists. They are having a trivia night tonight, and I accidentally copied and pasted it in there during Tim's presentation, but let me put it in correctly now. Sorry, Tim, that's my inability to manipulate my computer here. So let me see if I can send that to you. So if you're interested in trivia, that's something to do. There's my little advertisement. I guess if there's, I don't see any additional questions at this time. And I don't think we should prolong because we do, there are other sessions and other things going on. So I would just like to just make a final word here and tell everyone, all of the panelists and discussants, that I actually was really impressed with the quality and the clarity of all the discussions today. And I really appreciate it. So I just wish everybody a happy new year. And I hope to see all of you again in a future event. So thanks so much for today, and have a great weekend. All right, bye everyone.
Thank you.
Thank you.
So much.
Thanks everyone. Bye-bye.
Thank you.
I'm ending this, don't